Hello, Brian Weeks here again with another MMCD contract consideration. This video clip will cover the topic of choosing a CA to minimize conflicts of interest. The role of the contract administrator, CA for short, is unquestionably the most critical role in an MMCD contract. I can say without any reservation that having a qualified, competent, and professional CA will make any project run smoother and with less tension than otherwise, no matter how competent the other participants are. I've done a couple of other contract consideration videos on the role of the CA. They're entitled The Role of the CA and The Limitations of the CA's Authority. In them, I've touched on the inherent conflicts of interest this job contains, but I've not discussed what you, as the owner, can do to minimize them. In an MMCD contract, the CA's role in GC 3.6.1 is specifically designed to have a conflict of interest. We expect the CA to make impartial initial decisions about the requirements of the contract and the behavior of both parties to the contract. This is despite the fact that the CA is paid, either directly or indirectly, by the owner, who is one of those parties. This structure is intended to provide a counterbalance to the inherent powers of the owner to write the terms of the contract and to control the payments to the contractor. In our view, it is one of the strong reasons that the MMCD contracts have such an enviable record of not having to go to court to resolve disputes. We also recognize that in many cases, the CA either comes from or is the designer of record for the project and will have to certify the as-built drawings before the project can be closed off. This can impose another conflict of interest if the design proves to be deficient in some respect. For example, we've experienced situations where the CA, who was also the designer, was reluctant to approve change orders because then the owner would become aware of the design problems and would have to approve additional costs for their correction. So, protecting the owner's interests, the contractor's rights, and the integrity of the design makes the CA's job most challenging. In other videos, I've referred to this as the three-hat problem, to remind the CA that he or she must switch hats throughout the course of the project to fulfill the role properly. We wrote GC 3.6.1 to do several things. A. Commit the owner to recognizing the CA has to be impartial in some aspects of the role. B. Clarify what is expected for the CA and remind him or her of the fact that the owner agreed to this impartiality. And C. Reassure the contractor that the CA is required to be fair when evaluating contractor requests, payments, and owner behavior and demands. No one should have absolute, unappealable authority. As an aside, this is why many contracts in the 20th century had to go to court to resolve disputes. Recognizing this, the MMCD provides that either party can request a review of the CA's initial decision by filing a formal dispute notice within 10 working days. The process then allows others to determine if the CA's decision was correct in view of the actual contract requirements, or if it should be modified or overturned. But it is this requirement for impartiality which frequently is not well understood by some owners and some CAs. Even when clearly understood, it puts the CA into a difficult situation. So what can an owner practically do to reduce this problem? Under the MMCD, not having a CA is not an option. GC 3.1.1 requires the owner appoint one not later than the notice of award. Furthermore, GC 3.1.2 requires that should the CA depart before total performance, the owner is obligated to immediately appoint a replacement, so there is a person in that role throughout the project. These are mandatory obligations on the part of the owner. Failure to comply is a breach of contract, and the contractor would be entitled to file a dispute notice albeit using GC 17.3.2 in the absence of a CA. Now, the MMCD makes no comment on how an owner finds and selects a CA. This was intentional, as different projects require different degrees of skills and sometimes even different skill sets. Practically, the owner has three options. First, the owner can appoint a person from their own staff to be the CA. Second, the owner can appoint a CA from a consulting firm that did the project design. And third, the CA can source a CA from a person or firm which specializes in project management. Each of these has different advantages and disadvantages, as well as different implications on the degree of the conflict of interest that the CA will experience. When an owner selects a person from their own staff to be the CA, that person has the highest level of conflict of interest. This method does provide the following advantages. 1, it allows the owner to make use of a person whose wage costs are already budgeted. 2, it may enable some cost saving, as other sources will add overhead and profit to their charge-out rates. Theoretically, even staff of the same qualifications should thus be less expensive overall. Practically, it may be hard to measure the difference because of accounting policies. 3, a staff person will be best qualified to understand the owner's policies, procedures, and methods of work. The staff person may also have informal methods of getting support from others within the owner's organization that an outside consultant would not have. 4, owners often find that being a CA on smaller jobs can be good training for staff who will later progress to become project managers. On the other hand, this method has serious disadvantages. It's very difficult to convince a contractor that one of the owner's staff will not put the owner's views ahead of the requirement to be impartial. Owner's staff appointed to the role may not be well enough trained or sufficiently qualified to fulfill the role. I know of one situation where the CA would not make any decision without referring back to the owner and then writing up the owner's choice as the CA's decision. Third, from a practical point of view, a staff person put into this difficult role will naturally be concerned that making a decision unfavorable to the owner will have negative consequences on the CA's future remuneration and advancement prospects. To attempt to minimize these disadvantages, we recommend that the owner do several things. First, provide a comfort letter to the chosen person which assures them that the owner supports the concept of impartiality and that decisions with which the owner disagrees will not affect their future remuneration or job advancement prospects. It's best if this letter is signed by both the person's immediate superior and by someone senior in personnel or human relations. Perhaps by the time this video is posted, the MMCD will have a template for such a letter on its website. Check for it, as it is now currently in draft form. 2, make sure that staff is adequately trained to fulfill the role properly. It's unfair to simply drop an inspector into the job without a clear understanding of the difference in roles. 3, it's worthwhile for the owner's representative to make a public statement at the initial pre-job meeting that the owner fully recognizes and supports the requirement for the CA's impartiality. By going on record at the start of the job, this will reinforce the CA's confidence to be impartial and go some distance to reassure the contractor that both the owner and the contractor expect the CA to be impartial. Now to the second source. When the owner selects a person from the firm which did the construction design to become the CA, that person is one step removed from direct remuneration by the owner, thus lessening the perceived conflict of interest. If that person is the design engineer, this method provides the following advantages. 1, the CA will know the design better than anyone else and thus be most aware of which areas need critical attention. 2, the CA is in the best position to answer requests for information which deal with design deficiencies or constructability problems. 3. The CA will be routinely on site and can supervise the collection of the as-built data for subsequent certification of the record drawings. Even if the appointed CA was not the designer, but works for the same firm, the CA is then in a better position to get quick access to answers regarding questions that the contractor asks. However, this method does come with its own drawbacks. 1. There's an all too real risk that the designer will fail to see or refuse to acknowledge design flaws or deficiencies. Even when recognized, we've experienced situations where the designer was unwilling to generate the necessary change orders to fix a problem because it would reflect badly on the consulting firm. He expected the contractor to absorb the additional costs to protect his firm's reputation. You can guess how well that was received. Secondly, being a good designer does not automatically make one a good contract administrator. These require two different skill sets, and the owner needs to be assured that the designated CA has appropriate expertise for the job to run smoothly. 3. As the owner might also do, often design firms use smaller jobs as training spots for junior personnel. The same caveat applies. It is not fair to the person, the owner, or the contractor to put an insufficiently trained person into this challenging role. At the very least, the owner needs to be assured that the CA candidate understands the need for impartiality and recognizes that the construction contract language supersedes any provisions in the contract between the CA's firm and the owner, and also conflicts between consulting firm or owner policies and the actual contract language. To minimize the disadvantages when the owner chooses a CA from the design firm, we recommend 1. Ask the design firm to supply a CA who was not the designer of record. This will help to separate the role of the CA from that of the designer, while preserving a close relationship to ensure design parameters are not compromised. This gives the CA the ability to get quick assistance on design issues and perhaps even a second opinion on CA issues. The designer can be appointed as a site inspector, thus enabling site visits to verify design issues and to supervise the collection of data for the as-builts. 2. There will be a contractual agreement between the firm providing the CA and the owner. The MMCD provides a version called the Client Consultant Agreement, which you can order from our website. Whatever template is used, it should specify that if there are conflicting terms, the construction contract language takes precedence when dealing with CA issues. Finally, the owner needs assurance that the person to be appointed as CA has qualifications and expertise commensurate with the scope and type of project. Finally, the owner may be fortunate enough to engage a CA from an independent firm or sole practitioner who specializes in project management. This method provides the best, although not total, reduction in conflicts of interest. This method offers the advantages that, number 1, the contractor will have an increased likelihood of perceiving the CA is independent. Number 2, the owner will have an increased assurance that design issues are not being given insufficient attention. And number 3, the person will be a specialist in contract management and should be well versed in the intricacies and nuances of contract administration and record keeping. There are a couple of disadvantages with this method. 1, such specialized firms are not common and may be unavailable in more remote locations, particularly if the project is small. Even when there is a local firm, they may not have the time available when the owner needs assistance, or they may not have the expertise in the type of construction involved. For example, expertise in high-rise construction requires different knowledge from constructing an intersection. 2, again, because this type of firm is less common, those available may be more conversant with contract language other than MMCD, such as the Ministry of Highways contract or CCDC documents. This is not an insurmountable barrier for a professional firm, but the owner needs to be assured that the professional selected will be fully aware of the MMCD language and requirements before finalizing the appointment. To minimize potential conflicts of interest, the owner should 1. Verify that the proposed CA has no pre-existing conflicts of interest with the owner's relevant staff, the designer, or the contractor, if the contractor is known at the time of the appointment. 2. As with selecting from the design firm, ensure that any contract with the CA has language confirming superiority of the construction contract language in case of conflicts. 3. And obviously, given a choice, the owner should ensure that the proposed CA has the required expertise and knowledge of the nuances of the MMCD requirements. Once again, this is learnable, but the owner does not want to pay to bring the CA up to the required level. In all cases, the CA engagement contract must provide sufficient authority for the CA to perform the duties of the role without compromise. There will be times when a change order is essential to the work, whether or not the owner has budgeted for it. This does not mean that the CA should be able to authorize any change order without advising the owner, but in some cases it will not be discretionary for the owner to refuse approval. No matter where the CA is sourced, it's good practice in all cases to, number 1, clearly define the dollar value limits of the CA's authority to generate change orders without further approval from the owner. Different owners will have different policies in this regard, perhaps even for different CAs. Whatever the limits, these should be set out clearly in the CA's contract. We believe it's also good practice for the CA to reveal these limits at the pre-job meeting, so the contractor will know which requested change orders will take longer to process. 2. It's also best practice for the owner's representative at the pre-job meeting to announce that the owner understands and confirms support for the independence and impartiality of the CA in accordance with the contract language. Having this minuted will help to reassure the CA and the contractor. So, to summarize, number 1, MMCD contracts cannot function without a CA. This is a mandatory owner obligation. However, the job of the CA comes with inherent conflicts of interest, which makes it a very difficult role to fulfill. The most difficult of these is the requirement to be impartial when judging the performance of both parties to the contract. 3. MMCD puts no limitations on where or how an owner sources a CA. The owner can choose someone from their own staff, from the firm that did the project design, or from an independent project management firm. 4. Choosing from the different options, each brings its own advantages and disadvantages. However, in all cases, it's important to assure that A. The CA engagement contract specifies that impartiality is both expected and required in accordance with GC 3.6.1. B. The construction contract language has priority in case of any conflicting directions in the engagement contract or internal policies. And C. The CA engagement contract clearly sets out the limits of the CA's independent authority to authorize changes. 5. At the pre-job meeting, it's a best practice for the owner's representative to reaffirm the owner's commitment to the CA's independence and the requirement for impartiality. Well, I hope this has helped clarify this contract consideration. Please check our website for further assistance and to see what other topics are presented in this series. Thanks for watching.